Welcome, I'm Tom Howard, a commercial litigator with more than 10 years experience enforcing businesses' rights in the courts of law, and this is our Ask a Litigator segment. Our question today is quite straightforward. It comes from a longtime friend and a more recent client. What is a breach of contract? A breach of contract is one of the most quintessential causes of action at law. One of the reasons why America's great has to do with your ability to enter into binding legal contracts for business. There are trillions of dollars of contracts right now in America. The vast majority are all being performed. Performed, much like a play, is also a term of art in law for contracts. A contract is a promise to do something, and that promise then needs to be performed for a consideration. A consideration is kind of like paying for the ticket to see the play, which also has a performance. Plays and contracts in that sense are similar. So a breach of contract first requires the contract, and then something goes wrong. These breaches can be anything. Quite often, the breaches involve the money. And the money could be, or the product. Let's say you have an output contract for steel, and something goes wrong and you don't get your steel shipment. Or you have a contract, everybody has a contract for like a mortgage, let's say. And that mortgage needs to be paid, the mortgage note, and you fail to make a payment. These are breaches. And that would also be a default to the note, but that's a slightly different matter. A breach of contract happens when the performance of a contract is not done correctly. And it is against the terms of the contract. Many contracts, the good ones, will have a definition of what constitutes a breach of the performance of that contract, and then also their remedies. So a breach means to have something not be done, and if something is therefore not done, you can get a thing, and that thing, that redress, is a remedy. Now, does the contract magically do this? No. That's one of the cool, amazing, beautiful things about America and contracts and people in general. Most of the time they're honest and they are doing the right thing. They've entered into a contract and they're going to perform it. Very often, that's what happens. 95% of the time, that's what happens. Now, let's say there's a default, a huge default, a recession, because the economy grinds to a halt. Default, breach, then contracts go wrong. And that's also typically when lawsuits arise. Because after the contract goes wrong, you need to have it enforced. Only happens through a court of law. And then you need to make sure you have the right litigation attorney on your side, if it is for a breach of contract, if it is business. Because a breach of contract, really, when it comes down to it, is a cause of action with just 3 parts. It's kind of like this, well, it's nothing like this stool that I'm on, but it can be referred to as a stool, a tripod stool. You have a valid enforceable contract. A breach of that contract, aka something has gone wrong, you didn't make the payment, you didn't ship the steel, something has gone wrong, and C, damages as a result of the breach, something going wrong. The person who was getting the benefit of their bargain in the contract has been hurt. That, in a nutshell, is what a breach of contract is. Thanks for asking an attorney. I'm Tom Howard. Feel free to email me your contract question on one of the links on this webpage. And if you're watching this on the YouTube, give us a like and subscribe.